Family Law. This is your week 7 and 8 podcast. This will cover both of our weeks as we are going to, as promised, finish up before spring break. Having gone through divorce, annulment, which is declaration of invalidity of marriage in Illinois, and legal separation. And then you are going to interview a client and draft a divorce petition for that client in week 8. The most common fault grounds for divorce, and Illinois is no longer a fault state, but there still are fault state divorces, or for fault divorce states, I should say. The most common grounds were adultery, desertion, or mental and physical cruelty. Physical cruelty, having gone through what we just covered last week, should be fairly obvious. Mental cruelty, oftentimes, is what you read and discovered last week, is part and parcel of or very related to physical cruelty a lot of times. But in Illinois, leading up to our move to a no-fault state, essentially, I think it's fairly accepted that mental cruelty was a very loose term and used to be the ground of preference. We had 11 grounds in our old statute, and you either had to meet one of those grounds or live separate and apart for a period of time that wasn't exactly reasonable, considering the fact that what we know from, especially from our domestic violence situation, two people aren't getting along and don't want to be together, even under the most reasonable circumstances. It's going to be tough, but if it's an unreasonable circumstance or stressful or whatever, we could be promoting things that we don't want to be promoted for those people. So, no fault factors typically include the degree to which the parties are unable to relate to one another, the extent of any differences between the parties, prior efforts to resolve their marital difficulties, whether there's any hope for reconciliation, whether they're able to get back together, and then they have to live separate and apart. Illinois became a no-fault divorce state on January 1st, 2016, when we had a major update to our family law statutes. This particular act eliminated our fault-based grounds for divorce, as I stated, including adultery, physical or mental cruelty, abandonment, habitual drunkenness, impotent substance abuse, and the others. Part of your assignment this week is to really get to know and break down this statute. And when I say that it's easier for you today compared to prior to 2016 or January 1st, 2016, I'm not doing I walked uphill both ways to and from Illinois Central College in the snow barefoot kind of thing. Truly, it is easier for you to break down. And if you were doing an internship or working for a firm that has one of our former students who had family law prior to 2016, just ask them, because what you now have in the statute is about a third of what the combined, and maybe even less than what the combined verbiage and length of the prior two-part statute was. So you should have an easier time getting to know and breaking down the statute. Annulment in Illinois is called declaration of invalidity of marriage. More commonly, people refer to it as annulment. I just go ahead and get this out of the way now. A lot of people get confused because religious denominations, churches, the Catholic Church in particular is famous for it, granting annulments. Just because the church granted an annulment doesn't mean the marriage is annulled by the state. You have to go through the state's process. It's different than divorce. Under Illinois law, an annulment is granted, or when an annulment is granted, I should say, it declares the marriage invalid as of the date of the marriage. So, in other words, the court's saying that the marriage was never valid. It goes all the way back to the date of the marriage. Annulments are possible if particular grounds are met. An annulment is also legally different than divorce. There's statute of limitations, and some of the grounds for annulment carry different statute of limitations than others. An annulment has 4 particular grounds, and it does look to fault, as someone needs to be at fault for the annulment grounds to apply. Only the innocent party can request the annulment. There are grounds for annulment, and those grounds are: one of the parties to the marriage lacked the capacity to consent to the marriage at the time they were married. And we went over capacity to be married back when we talked about marriage weeks ago now. One of the parties to the marriage lacks the physical capacity to consummate the marriage, and the other party did not know of that incapacity. So one of the parties is impotent, unable to consummate the marriage. I'll just leave it at that. And the other party didn't know about it at the time of the marriage. One of the parties to the marriage was 16 or 17 at the time the marriage took place and didn't have their parents' or guardians' consent. Think back to when we talked about marriage, and all this kind of comes in, right? And makes sense. Or our public policy considerations. The marriage is prohibited by law in Illinois. Now, we're not going to see a lot of annulments in the courthouse, just because if you think about those things, it's just not as likely to happen. Those grounds aren't as likely to present themselves in 2023. But who knows? In addition to the annulment statute, we have legal separation. I should say, again, going back to the thing that people get confused about, the church and the church providing an annulment, you'll find that fault is not really a factor, I guess, in the church's determination. That the church, a lot of times, is dependent upon, who initiates it and who pays. I can tell you that, my father took off when I was 7 years old with 3 other children younger than me, and really provided absolutely zero support to my mother for our entire lives. And sometime around the time I was 18 or so, he paid to have the marriage annulled. And a priest came up to me and thought it was a great thing that, your father, got his marriage annulled. He can now participate fully in the church. And I was incensed, because if understanding annulment to mean the marriage was never valid, it meant, that the 4 of us kids were not valid. Now, we know that Illinois, all kids are legitimate kids and there's no illegitimacy, but I told the priest, so you're saying I'm a little bastard. I was pretty indignant about it and pretty upset about it, because I didn't see how on earth that could be, because he was clearly the party at fault. That's my own personal experience, but other people have had similar experiences. Just know that that's why it doesn't come up in court a lot, because in court, courthouse, we expect evidence, and we expect things to be proven up, and so that's a whole different situation. And just know that one doesn't equal the other. Legal separation in Illinois. Legal separation is a decree that the parties have good cause for living apart. It doesn't terminate the marital relationship, and the parties can't remarry. It can address child support and care issues and spousal support issues. It doesn't divide up the property per se. So it's a little different situation. Now, why would people want a legal separation? And you see fewer and fewer legal separations, but there may be a good reason someone would want a legal separation. They may believe that reconciliation in the future is possible between the two parties. They may believe that they want to use legal separation as a trial run before they decide if they really want to get a divorce. They may want to avoid the social stigma that comes with getting a divorce. They may have certain cultural or religious beliefs that prevent them or hinder their ability to get a divorce. They may want to create a more stable environment for their children before they get a divorce. They may want to retain benefits that come from being married, such as health insurance, security, or pension. And I've known people that have lived in two separate houses for decades. Legally, they were married, but they hadn't lived together for decades. And they may need some space, just some time and distance to think about what their final decision is going to be. Final decision meaning they want to move towards divorce. Let's talk a little bit about week 8, because as I said, this is for your week 8 or 7 and 8 podcast. Sometime during week 7, week 8 will be opened, and week 8 will list who your client is. You are to interview whoever I assign you to interview as your client, meaning that the two of you need to get together. You can get together in person, you can do it remotely, but you have to be looking at each other. So it's either going to be on a remote access, or you're going to meet somewhere. You can meet at Poplar Hall at the Peoria campus and sit out in the student area, or an open classroom, or at the student center. But you do need to be face-to-face for this interview. You're going to interview someone, and you're going to draft a divorce petition for them, and then you're going to post both your interview sheet with all the information and your divorce petition, and then you are going to review the divorce petition that the person who drafted it for you has posted. So you're not going to have to review everybody's, but you are going to have to review the person who drafted your divorce petition and comment on it in a constructive and open and honest way, if they got things accurate, if they did things to the best of what we expected, etc. And you'll have to do that, all of that, before the end of next week, week 8, and before we go to spring break. Now let's talk about preparing to interview your client. There's some things to remember. First off, and we've covered this a few times, there are emotional contexts to these family law situations. So we really want to keep in mind that the other person, the person we're interviewing as the client, and sometimes when we're interacting with the other party, the other spouse who isn't our client, it's very emotional. And we have to be balanced, and we have to make sure that we don't facilitate their emotion necessarily, but we don't ignore it either. And we don't want to get emotional ourselves. There's ethical considerations that we've talked about, and you need to keep those ethical considerations in mind, especially confidentiality, especially going back to the lawyer for approval. Some of you have had civil litigation, so you've had practice with interviewing a client, and you've had a lot of discussion about active listening. If you haven't had that, just briefly, active listening is looking at the person, hearing what they say, but seeing them say it. See their hesitations, their verbal, nonverbal cues, the face they make. Are they hesitating? Are they answering, directly? If they're hesitating, that could mean they're uncomfortable providing the answer, or they're not trying to tell us everything we need to know. But you need to keep in mind that in doing your active listening skills, you aren't the detective interviewing a murder suspect in an interrogation room. This is your client, and so you want to make sure that the client has, your confidence, that they, and I'm not talking about attorney-client confidence. I'm talking about the client is confident that you are here to hear them, to take down the information that you need to help get the divorce petition together, to help, in this case, initially you're going to do the interview to provide information to the lawyer. A lot of our family law graduates or our legal assistants and paralegals working in family law will tell you that they do the initial intake, they do the initial interview of a potential divorce client before the lawyer ever sees or talks to that individual. They take the information back to the lawyer. So this is kind of a hybrid because we have only a couple weeks to cover this, but I want you to go about it in that vein, and I want you to really pretend you are the legal assistant trying to get this information. But keep those things in mind, that you want that person to be confident that they can be forthcoming and be complete with you. And then when you're playing the client in this exercise, don't do it halfway, all right? Pretend to be the client. Really be prepared, know your facts, don't have to look it up on paper, just be a good play actor. When you're doing these interviews, you have to remember to stay level, be patient, be unemotional, but active listening. See and hear what they say. And then if they're still not, they're still hesitant, if they're still struggling, if they're emotional on certain things, make a note of that to share with the lawyer, because the lawyer is going to want to know. What would typically happen then would be the lawyer would decide if it's somebody they want to take on. They would meet with the individual, and at that point, if they decide to take the case, then we've talked about the lengthy client contract. Hopefully they have a good client contract, and they're going to get a retainer from that individual, and then they're going to represent the individual thereafter. We're kind of cutting through all of that, and we're just going to assume that we're going to take this person, and you can assume that you met with the lawyer and the lawyer's met with the client, and now you're going to draft the divorce petition. But for the interview, I want you to keep some stages in mind. There's three primary stages for a client interview, and if you do these things and things I asked for this week, and you obtain the client interview intake documents, and you really work to make one for yourself, you can see these stages play out on the document. There's the opening stages. That establishes the parameters for the interview and creates an atmosphere of trust where you tell the person, you're here to gather information on behalf of Mr. Higgins, the attorney, and the client can provide you with all that information openly and honestly, and knowing that it's going to be held in confidence and nobody else will see that information except for the lawyer. Then you get into the information gathering stage, and it elicits the client's basic story. It fills in key details. It does that starting with basic information: name, address, date of birth, kids, work history, education history, etc. And it goes on down through all of the information regarding why they're here to see you, in this case, a divorce. If you think about the statute and you think about what you're eventually going to put on the divorce petition, the client intake should gather the information that you're going to need for that purpose. To gather all that information, you're going to have to go back in discovery and do some work later, and you'll get more information, but you get that basic information on that client intake sheet. And then you wrap up and disengage. It concludes the interview, and you always want to leave the client with an idea what the next stage is. So if the next stage is you're going to review the situation with the lawyer, and then they'll get back, or you'll get back with the client to decide whether or not the lawyer is interested in meeting with them, or whatever the case may be. And you should know this, what your parameters are before you go in. You don't make up those parameters. Get that information from the lawyer, but make sure the client knows what to expect next. If you know the statute, you have a divorce-focused client intake document, and you prepare for your interview, both as the legal assistant and the client, in a serious way, really pretending to be the role. And if you really put in the time and do your best to draft the divorce petition to the best of your ability, you're going to gain the experience this assignment's going to allow. Now, regarding your divorce petition, I provided an example for you. You'll note that the petition is bare bones regarding facts. You aren't providing an argument to win your case. You're not arguing your case with the petition. You're stating the facts relevant to the requirements of the statute, and your petition should follow the expectations of the statute and look very much like the example provided to you, with the exception of having your client's facts and circumstances listed accurately. I hope and suggest that you really take this week and next week, and especially the interview and the divorce petition, seriously, that you really own this and look at what that petition requires, know the statute, and do your best to provide a document that looks a lot like the examples that I provided and the examples in ICL, because that divorce petition has been a good writing sample, especially for people who go out to interview for litigation firms. Even if it's not a family law firm, remember, family law is litigation. So and those of you from who have had civil litigation in the fall will be able to attest to this. Once you start to really get into this divorce petition, it's a complaint. Petition's another word for complaint. Okay? So have that focus, put in that effort, do the best you can. We're going to conclude by Friday of week 8, and then we're not doing anything. I'll release the week 9 assignment sometime during spring break, but after week 8, we're off for a week. So you don't have anything you have to do. If you wanted to log in and get going on week 9, it'll be up there. I appreciate your efforts through these first 8 weeks. If you need me, you know where to find me.